Hi guys, welcome back to Sensei. My name is Olani Oyindamola David, and today we're going to continue with the past question and answer series. And today we're going to be looking at question 4 of 2016-2017 of criminal law. So question 4 says that Melaye, Odion, and Richie, cognizant of Chief Darocha's affluence in the village of Owode, agreed to steal his money and his wife's trinkets. They put up the uniforms of census officials from the National Population Commission and knocked on the entrance gate of Chief Darocha's house. After falsely identifying themselves as enumerators, Chief Darocha's wife allowed them into the sitting room where she was staying with her husband in order to perform their stated duties. As they entered the apartment around 2:30 p.m., rather than enumerating the occupants, they manhandled Chief Darocha, requested him to bring out money from his room, and he obeyed them. Meanwhile, Melaye brought out his pistol and shot into the ceiling, and thereafter pointed the pistol at Chief Darocha's wife, asking her to bring out her trinkets, despite the fact that they had all agreed not to use arms. In the course of dispossessing Chief Darocha and his wife of their possessions, Bosa, a neighbor, upon hearing a gunshot, alerted the police about it. The police arrived at the scene while the operation was going on, but decided to lay ambush at the entrance gate, awaiting the exit of the felons. The trio exited the apartment around 6:35 p.m. through the kitchen's window as the kitchen door was locked. On their way out of the premises, they attempted to force open the door lock of Chief Darocha's Lincoln Navigator Jeep, parked in the compound, in order to escape with it, but were unsuccessful. They were eventually arrested by the police as they made their ways out of the entrance gates. Consider the criminal responsibilities of Melaye, Odion, and Richie. And so, if you've been paying attention to the rendition of the facts, you would see that the facts touch on the offenses of housebreaking, burglary, robbery, armed robbery, and malicious damage to property. And so, we would have to raise issues, touching upon these offenses. And you have 3 issues. You have whether Melaye, Odion, and Richie are guilty of burglary or housebreaking, whether Odion, Melaye, Richie are guilty of robbery or armed robbery, and whether Melaye, Odion, and Richie are guilty of malicious damage to property. So we're going to be looking at the first issue, which touches on burglary. And if you've been following, you have to adopt an ingredient approach once again. For burglary and housebreaking, the relevant section is section 411 of the Criminal Code, which criminalizes breaking in and entering into another person's property with the intent to commit a felony, or having entered with the necessary intent broke out. And if that breaking and entering occurred during the day, is referred to as housebreaking. If it's done at night time, it's referred to as burglary, with the punishment of 14 years and life imprisonment respectively. So you need to establish the elements of housebreaking or burglary. But preliminary, night time is defined by section 1 of the Criminal Code to be between the hours of 6:30 p.m. to 6:30 a.m. So you need to establish the elements or the requirements in grounding a conviction for housebreaking or burglary. There must be breaking, there must be entering, there must be necessary intent to commit a felony, there must be the existence of a dwelling house, and then breaking out. So for breaking, it's defined by section 410 of the Criminal Code. Entry is also defined by section 410 of the Criminal Code. And breaking is done when you lift any flap, you open, you unlock. So section 410 provides various instances where you deem to break in. Then entry is based upon the rule known as the slightest entry rule. You need to look at the case of R against Boyle as compared to the case of Brown, as R against Brown, which involved the substantial entry test as decided under English law. Then there are various types of breaking rather. You can either have constructive breaking in, or you can have actual breaking in. Constructive breaking in is when you make use of any artifice or trick or deception in gaining entry, and breaking and entering can also either be internal or external. So you need to look at the cases that touch upon that. Then you need to establish the fact that there was a necessary intent to commit a felony. And mind you, necessary intent to commit a felony is not restricted to stealing. It includes rape, murder, stealing, and all sorts of things. In case you see facts that includes robbery, armed robbery, and so far it constitutes a felony. And you know the definition of a felony. Felony is an offense stated to be a felony and also punishable by a term of imprisonment of 3 years or more. So you have the requirement of a dwelling house, and a dwelling house is defined by section 1 of the criminal code. And the most important thing to note about dwelling house is that it is the use to which that dwelling house is put that is important. So you can either have a caravan, a kiosk. So far, the people there have decided to put it to a purpose such that they live there. They need to constitute a dwelling house. Then breaking out. Breaking out involves a situation where there was a constructive breaking in. So what will now be relevant is the time of breakout. So there are a number of principles that you need to note. If breaking in and entry must be during the day of the same day to constitute housebreaking. But for burglary, breaking in can occur during the day, but there must be entry at night. Or breaking in and entry must occur at night, rather, I beg your pardon. Breaking in and entry must occur at night, but they need not occur on the same night. So you can break in, or you can break into the dwelling house this night, and then you can enter the dwelling house the next night. It will still constitute burglary. Do you understand? So there are separate punishments, and you need to note that. So with application or in application to the instant facts, you see that the particular persons concerned, that's Melaye, Odion, Richie, gained entry into the premises through deception. They represented themselves to be what they were not, and this is similar to the case of Aaron Boyle. So you need to note. So there was breaking in, and they entered with the intent to steal, and they broke out. So you need to look at the relevant time of breaking in, entry, and breakout. So they broke out by 6:35 p.m., which is now night time, as defined by section 1, and that's burglary. And you need to know that the punishment will be life imprisonment. So the second issue is whether Melaye, Odion, and Richie are guilty of the offense of robbery and armed robbery. So once again, you need to note that section 401 defines what robbery is. You need to establish the requirements of robbery. There must be an intent to steal. There must be the use or the threat of violence, and the threat or use of violence must be immediately before, during, or immediately after the obtainment of the property. You need to establish the other allied principles as it relates to robbery you need to look at the cases of Adejobi against state, Adekbojo against state, Corcoran against Anderton, amongst others. Okay, so you need to also look at the offense of armed robbery, or also known as aggravated robbery. And for that, you need to look at section 402, subsection 2, A and B. And you need to look at the constituent elements of armed robbery. So for the elements of armed robbery, there must be an intention to steal, of course. There must be a robbery or series of robberies. And 3, the robbery must be armed. And what would constitute that is the use of any firearm or dangerous weapon, as the case may be, or the use of any chemical or obnoxious substance. And it is punishable by death You understand? You might also need to look at the provisions of the Robberies and Firearms Decree of 1970, the relevant provisions, section 1, subsection 1A, as the case may be. And so in application to the instant facts, you need to establish that, of course, there was a robbery. After the three persons have satisfied the elements, there was an intention to steal, they made use of force, and the elements of robbery. Then for aggravated robbery, you find out that one of them made use of a pistol in getting whatever they obtained from Chief Darocha. And the pistol, of course, comes within the definition of arms or ammunition, as the case may be, and that is armed robbery. Also, you need to look at the fact that whether or not they all agreed that one of them was going to carry arms or ammunition. If they all agreed, then the possession of arms or ammunition by one will be regarded as possession of arms and ammunition by the three of them. However, if there was no agreement to that effect, only one of them will be guilty of armed robbery. And in that case, that is Melaye. I believe that is Melaye. And so the last issue is whether or not the three parties, Melaye, Odion, Richie, are guilty of the offense of malicious damage to property. And for that, you need to look at section 451 of the Criminal Code, where it says that where you willfully and unlawfully cause damage to the property of another. And for this, you need to look at a number of cases, Cox and against Riley, amongst other cases. You also need to look at the provisions of section 440 of the Criminal Code, which defines the word unlawfully, do you understand, as it relates to offenses within that particular chapter of the Criminal Code. Okay, so you need to look at the case of Aram Pebbleton, in establishing this offense. And you also need to realize the fact that the property need not be completely destroyed. It covers situations where the damage is such that the utility of the particular goods cannot be achieved. And the popular example is if you have a car and your mechanic removes the battery or destroys the brain box of the car. Of course, without brains, the car cannot work. So that's malicious damage to property. So in this instant facts, you need to establish whether or not the attempt to make use of the Lincoln Navigator Jeep was malicious damage to property. Maybe they destroyed the handle or they destroyed something in trying to enter the vehicle. And so that's the end of this particular question. Thank you for listening. Do not forget to subscribe. Please leave your questions in the comment section. Bye.